Hello all, my name is Thomas Herbst and I'm an attorney with Zeiler.partners here in Vienna. In this video, I'm going to give you a short overview of two doctrines common to most arbitration laws. That is, competence on the one hand and the separability doctrine on the other. Now, while these two legal concepts are indeed distinct from one another, they are nonetheless regularly discussed together. And that is because both doctrines have a similar goal, namely protecting the independence of the arbitral process from the intervention, for example, by state courts, and safeguarding the parties' agreement to arbitrate. I will hence do the same in this video and address both doctrines jointly. In doing so, I will also shortly touch upon whether and how these concepts have been transposed into Austrian law. So what is competence, and how does it go about protecting the independence of the arbitral process? Essentially, competence means that the tribunal enjoys the inherent power to rule on its own jurisdiction to decide a dispute submitted to it. Importantly, this includes cases where an arbitral tribunal eventually finds that it has no jurisdiction because the arbitration agreement, which is the basis for its perceived jurisdiction, is null and void or inoperative. However, one should be mindful that competence does not mean that the arbitral tribunal always has the last word on its jurisdiction. While the tribunal is regularly afforded the freedom to reach its decision on jurisdiction independently and without interference from the court of law, these decisions are not necessarily final. In Austria, for example, and very similarly in other jurisdictions such as Germany and Switzerland, certain aspects of these decisions on jurisdiction may be reviewed by the courts of law in the course of, for example, annulment proceedings, as well as at the enforcement stage. Hence, in questions such as arbitrability, it is the state courts that have the ultimate say on the jurisdiction of the arbitral tribunal. While the principle of competence is widely accepted and expressly set out in Article 16, for example, of the Antitrust Model Law, states have designed various and different rules on how to effectively implement competence. The Austrian legislature has devised the following procedural mechanism in this regard. First, besides expressly stipulating that arbitral tribunals are competent to rule on their own jurisdiction, the law also provides for a complementary, so-called negative aspect of competence. It sets out that where an action is brought before an Austrian court, the court generally must reject the case for lack of jurisdiction if the matter is subject to an arbitration agreement. Further, according to statute, even if a matter has been brought before a domestic court, this does not bar the subsequent initiation and conclusion of independent arbitral proceedings on the same subject matter. However, where a matter is already pending for an arbitral tribunal, courts must reject any later application on the same subject matter until the arbitral tribunal has rendered its decision. Finally, once an arbitral tribunal has determined that it lacks jurisdiction to decide a case, courts cannot refuse to take on the case by relying on the existence of an arbitration agreement. As you can see, competence essentially protects the independence of the arbitration by ensuring that arbitral tribunals can determine the jurisdiction without interference by the courts of law. So what is the second concept, the doctrine of separability that I have mentioned initially? The separability doctrine is the legal concept that an arbitration clause contained in the main contract should be treated as a separate contract. Not only is the separability doctrine expressly stated in the same Article 16 of the Antitrust Model Law, which I have mentioned before, it's also part of arbitration laws of various non-model law countries, most notably the UK and the US. The ultimate consequence and the purpose of the doctrine of separability, indeed, is that defects of the main contract are said not to impact the validity of the arbitration agreement. Thereby, the unenforceability of the main contract does not automatically render the arbitration agreement contained within it unenforceable. For many jurisdictions, it is only because of the separability doctrine that arbitral tribunals can assume jurisdiction to hear disputes on the validity of the main contract containing the arbitration clause. While the Austrian legislature has consciously not adopted a law spelling out the separability doctrine, it is nevertheless widely accepted in the case law of Austrian courts that, in certain respects at least, arbitration clauses must be assessed separately from the main contracts. By referring to the hypothetical intention of the parties while interpreting arbitration clauses, case law has created various exceptions to the general rule that all clauses in one contract also enjoy the same fate. For example, courts have held that, when in doubt, disputes on the initial validity of the main contract are within the scope of a formally valid arbitration clause. Further, courts have also held that arbitration clauses survive the unilateral termination of the main contract by one party, and that claims arising from the terminated contract or the termination are thus within the scope of the arbitration clause. In the context of corporate disputes, even claims arising after the dissolution of a corporation have been held to be within the scope of the arbitration clause contained in the Articles of Association. In summary, therefore, despite the lack of express reference in statute, to a substantial degree, Austrian courts in fact do recognize the separability of arbitration clauses as well.